Okay. Hi, everybody. My name is Romy Jurado. I am here today to speak to you guys about trademarks, a little bit about copyrights, and we can touch on intellectual property. I am a partner here at Jurado and Farshin. I'm talking to you all from my law firm. We are a law firm that specializes in real estate, business law, trademarks, copyrights. We also do litigation, and we cater to the realtor community. I have a lot of realtors that are my clients. And so this presentation, even though it's about general trademark law, I want to make it, I guess, as useful for you and your clients. If you have any questions at the end of the meeting, you guys can ask via the Q&A or in the chat. I see a couple of questions now. Okay, everybody's saying good morning. Good morning, everybody. I hope everybody is doing well with everything that's going on in this craziness, but you know, you guys realtors and us attorneys, we're here to service the community, so we just have to survive and thrive through it all. All right, so now that I have your attention, I'm gonna start my presentation. I'm gonna share with you my screen. Give me just 1 second. And let me put my contact information. Somebody's asking for it, sure. Let me just put it real quickly so it's that's my email, and then this is my number. And my office is in North Miami, but we cater to clients all over the state of Florida. Trademark is actually federal law, so we cater to clients all over the United States. Okie dokie. So there I am. This is my presentation. Let's start. Trademarks. So what is a trademark, right? Why do you care about it? Why is it important? A trademark can be anything that is a word, a name, phrases, symbols. To give you more context in the realtor real estate community, for example, if you're operating under a group, right? So you guys are a team and you have a special name for your team, whatever it is, you know, the fabulous Marias, the, Selling 305, whatever you guys call yourself, that name that you've developed is something that you want to protect. Because let's say that you came up with something really good, right? So whatever name you guys came up with, let's just use the Fabulous Marias. And everybody starts knowing you by that name. Oh yes, I want to list my property with the Fabulous Marias. They're so great, they're so fabulous. And then somebody else, you know, like literally your office is in Brickell and somebody in Aventura starts calling themselves that. They develop social media handles, they develop a website, they do everything, and they have more of a marketing budget. So now they're paying for ads left and right. Can you do something to stop them from using that name and that brand that you've worked so hard to develop? No, you cannot. You cannot unless you have a registered trademark. Okay. Now, yes, the moment that you start using the name, it develops some protection. But if you really want to stop somebody from using it, you need to have a registered trademark. So you can register a name, such as the name of your, for example, the name of your brokerage, whatever name that is. If you want to protect it, you don't want another brokerage to open up with the same name, you need to register that name. People think that it's enough to register it in Sunbiz, in the Florida Department of State. That, you know, as long as you register your company there, nobody else can use that company name in the state of Florida. Now, while it's true that if I go, for example, and register a company in Sunbiz, right, with the name, no other company can have the same name as their company name with the same ending, such as Corp, LLC, and all of that. But the problem is that they don't have to form that name. They can form any name and then file something called a DBA. A DBA means doing business as, and basically what it means is that you can form a company name. Let's say the company, it's called Cats Inc. That's your company, but you want to do business as Dogs Are Fabulous, you can do that. So unless you protect the trademark, you cannot stop somebody else from filing a DBA, doing business as or fictitious name, and operate their business under your trademark or name that you came up with. So that's why it's important. You can protect a name, you can protect phrases, like, you know, selling all day, every day. If that's your phrase that you want to protect and people come to know you because of that, and you don't want other real estate professionals to use that name, or sorry, that phrase, you know, selling real estate all day, every day, then guess what? You need to protect the trademark. Otherwise, you cannot protect it. And the same works the other way. I've had situations where clients come to me and they're like, Romy, I received this cease and desist letter. I've done all of my marketing under this name, and now somebody in Washington is telling me that they have that registered trademark and I need to stop all usage of it. And then the client is, you know, like, why would I have to do that? They're in Washington. They're not here. How can they stop me from using that name? I've done all of my marketing, all of my branding. Now I would have to start from zero. They can stop you. Why? Because trademarks, if you protect them right, they're federally protected. That means that you're here in Miami and you can stop anybody from using it anywhere in the United States. Same thing happens with them. If somebody has a registered trademark in Washington State, in New York, wherever, even though you've never heard of them, they can still stop you from using that name. Okay, so what is a trademark in reality? It's anything that you use to identify and distinguish goods from those manufactured or made by other people. Okay, and in your industry, the real estate industry is so important because branding is so important. People may not just remember your name, they remember your slogan, they remember your team, they remember things like that that you definitely want to protect. Because then now, let's say, and I've actually had this particular situation. I had a client who had a registered trademark here in Miami for the service they were giving. And somebody found out about it. They really liked that catchy name. And they said, listen, I know you have a registered trademark for that service you're providing. I would like to do the same in Orlando. And the client came to me and it's like, look, this person came to me. They want to provide the same service using the same name. Do I need to franchise? Franchising is great, but it's really expensive. And I said to him, no, you don't need to franchise. What we need to do, since you have a registered trademark, is we can license them your name, okay, with a special license agreement that at any time you can just take it from them if they don't do what you want them to do, meaning pay you royalties, so there you're making money, and abiding by whatever your brand guidelines are, because you don't want them using your name and putting it with things you don't want to be affiliated with. So the client was able to do that, to license the trademark they had protected and make money in royalties. Those people in Orlando were providing those same services the client was here in Miami. It didn't cause any conflict with the client because the client was okay just providing those services in South Florida. And as a matter of fact, they started doing business together. This wouldn't have been possible without a registered trademark. What would have happened had this person not had the registered trademark is this person in Orlando would have seen their name, would have realized, whoa, how catchy. That's such a fabulous idea. Let me go do it in Orlando and let me go ahead and register my trademark myself. And then a couple of years down the road, or maybe right after, send the people in Miami a cease and desist letter to stop using that trademark. Now, because they started using it before, they maybe would have had an argument to fight it, but it would have cost them a lot of money. So that's why it's important to protect your marks, your trademarks. There is a difference in language. A lot of people know it by trademarks, but in reality, if it's a mark that is protecting a service, right, then it's usually called a service mark, but it's a trademark. For example, American Airlines, AA, is the service mark. They're providing airline services. McDonald's is the service mark. They're providing restaurant services. Protection is available because you can prohibit anybody else from using that service mark or from using things that are similar to that service mark. Why? Because it would create the likelihood of confusion. Let me give you an example. Let's say that your service mark is the Fabulous Marias of Miami's 305. So that you started selling real estate services, everybody knows you by the Fabulous Marias of Miami 305. Somebody else comes along and they're calling themselves the Fabulous Elenas of Miami 305. We would have a good argument to say that that is creating the likelihood of confusion and they're basically taking from your brand, and we would be able to send them a cease and desist letter if you have a registered trademark. Why? Because we could say that we're targeting the same customers, that the name is very similar, that they're using a lot of the words that our trademark has for the same exact services, and we would have an argument. Okay, so you can do all that with a service mark. Marks must be distinctive, okay? So the trademark law only protects distinctive marks. They have to be arbitrary, fanciful, and suggestive marks are deemed inherently distinctive. Descriptive marks, right, such as geographic names, surnames, and are not inherently distinctive and can only be protected if they can be shown to have attained distinctiveness through the use referred as secondary meaning. Generic terms are not protectable, such as, for example, to give you a generic term, you can never trademark the word apple to sell apples. Okay, why? Because it's a generic term. You're describing an apple to sell apples. Just like you can never trademark, and it's there, you can never trademark pencil to sell pencils, or good pencil to sell pencils that you're claiming are good. That's a generic name. It's not going to be trademarkable. But you can protect Apple if you're selling computers, like we all saw, no problem. Okay, so what is arbitrary? Arbitrary is the use of words that are in common use but bear no relationship to the associated goods. For example, Apple, it's a common word, but they're able to protect it for computers. So what is suggestive? Suggestive means some quality or character of the associated good, but it's not so explicitly that no imagination is needed to determine the nature of the goods. For example, Copperton for suntan lotion. You know, you can make that connection, Copperton to suntan lotion, but it's not so clear that they're not going to be able to obtain protection for that. Okay, fanciful. Okay, let me see, I think I have 3 questions. Maybe I can address them now. Okay, so regarding price and all that, I will give you that information when I send everybody a follow-up email, because sometimes we're not allowed to discuss pricing, and it also depends on the type of trademark and everything else, but we'll discuss that, and I'm really reasonable with pricing. Okay, so fanciful. Fanciful is composed of coined words, like Xerox for photocopiers. So when you're developing your brand name, your trademark, if you want to protect it, try to come up with things that are arbitrary, suggestive, and fanciful. That way you're going to increase the likelihood that your trademark is going to be granted. Something descriptive, okay, it could be protected too. For example, beef and brew for a restaurant. But something generic, it won't be. For example, apple for fruit, or beer, or something like that, beer for beer, it won't be, because you cannot protect you cannot protect something that clearly describes what it is, because it would be unfair, and then nobody else could use that word. It doesn't make sense. So you cannot protect those things. So the whole trademark law, the way that it works, technically registration is not required. What matters in trademark law is who used it first. However, to be able to send a cease and desist letter, to be able to defend an action in the federal courts, and to have the right to receive attorney's fees and costs, you want to have a registered trademark. Okay, and you want to do it, there's 2 ways to register a trademark. One is that you already are using it in commerce. Okay, so that means it's already being used. And then the other one is that you plan to use it in commerce. So when I have clients telling me, Romy, when should I register my trademark? As soon as you come up with a really interesting name that you want to use, and you know what services you want to use it for, you don't have to wait until you're actually using it. We can protect it saying we have the intent to use. Other things that we do is, for example, I have clients that come up with a nice name for a restaurant, and they already are providing those services through the restaurant. But in the future, they also would like to develop T-shirts. They would also like to develop hats. They're not doing it at the moment. So what we do is we register the trademark as in commerce use for the restaurant class, and then we say that we plan to use it for the, to develop hats, to develop T-shirts, to develop any other merchandise. I had a client that was planning to sell knives. No problem. So you can say what you're actually using and protect it, and then you can do intent to use and protect for the future. I have clients, because I help a lot of people in the restaurant industry, that come up with really cool names for a restaurant, and they don't plan to use it maybe in a year. So the way that we do it is we'll protect that name for right now, right? They get 6 months, and then every 6 months they have to file a renewal of their intent to use. I think the maximum we can do it is 5 years. So the good thing is the protection will be backdated to the date that you filed that intent to use, and nobody else can use the name. So if you come up with a really cool name of a service or something you plan to use in the future, and you register it, or at least you file the intent to use, and somebody else hears you and they're like, oh, that's such a good idea, let me go open the business right now and let me go register the trademark, they won't be able to do it, because even though you're not actively using it in commerce, you said that you had the intent to use. After 5 years of obtaining a registered trademark, we can file something so that you remove any and all contestability. So you file your trademark, you obtained it. People can try during the first 5 years to file actions to say, no, but I really was using it first, or blah, 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 and then try to come after you. But after 5 years, we can file something so that it's NOBO, they can no longer contest it. Okay, we file an affidavit of continuous use that you've been using it all throughout, and now they cannot contest it anymore. Let's talk about the symbols. A lot of people get confused. So the R, the little R with the little circle, the register symbol, is used by trademark owners to give notice that a particular mark is registered with the USPTO, with the United States Patent and Trademark Office, for a particular goods and services. That means you have registered a trademark. You know, you have federal registration. It has been granted. Not that you just filed it. It means it has been granted, and now you can let the world know, this is my mark, don't use it. Who has that? Realtor. Realtor is a registered trademark. You know, you can be a real estate agent, but unless you're part of the National Association of Realtors, you're not a realtor. Realtor has a registered trademark. So they get to use the little R. If you have a catchy name that you developed, right, and you want to give it some level of trademark protection, then you can use the TM symbol. The TM symbol is used by trademark owners before they obtain a federal registration for their trademark, okay? The use of the TM symbol, while not required by trademark laws, can serve many useful purposes for a trademark owner. You know, it lets somebody know that that is a trademark that you're trying to protect, but it's not protecting. Now, one thing that I want to make clear, while federal trademark law is the one that I'm referencing to, every state has its own trademark office. So I can go and register a trademark in the Florida Department of State and protect it in Florida. Somebody can go and protect it in Washington. Somebody can go and protect it in New York. I don't recommend that. Why? Because that protection, it's only for the state of Florida. But if somebody goes and tries to file a trademark at the federal level, you may be out of luck. So you don't want to do that. You want to protect at the federal level in every state, okay? So the way to do that is to do a federal trademark. And that way you're protected in Florida, you're protected anywhere, nobody else can use it. And if somebody ever uses the name, you send them a cease and desist letter to stop all usage. And if they don't, we can go ahead and sue them and recover attorney's fees and costs. All right. I want to talk to you guys, and I know the laws can be a little boring sometimes, but just real quickly about something called the DuPont factors. The DuPont factors is how the United States Patent and Trademark Office will decide whether the trademark that you're trying to register and one that is already registered should be registered at the same time, or if they will create a likelihood of confusion. That's what the United States doesn't want. They don't want that the name that you're trying to protect will be confused with other names, and therefore they will deny your trademark registration. The DuPont factors that they look at are, for example, and these are things that you may want to think of when creating your own name, the similarity or dissimilarity of the marks in their entireties as to appearance, sound, connotation, and commercial impression. You can trademark a sound. Okay, you can trademark. I have seen sound being trademarked because it's so distinctive. Like, for example, the ringtone of the T-Mobile, I'm sure you guys have heard it. There is, in all these rap videos, there is this sound that is like, brr, brr, brr. My cat used to do it. I wish I would have trademarked it. I didn't. But that sound is trademarked because they use it in all the rap videos, and it's really, I guess, popular. Anyway, the similarity or dissimilarity of the goods for which a mark's being used, the similarity of the channels of the trade. We actually had a case similar to this. So we had two similar trademarks, okay, that we were trying to register with. There was already a registered trademark, and ours, we were trying to register it, and it was similar to another trademark there. It was within the same class. However, we said to the United States Patent and Trademark Office that it was going to different channels. What does that mean? This mark that was registered was a really fancy mark, was for fancy products, really luxury goods. The marks that we were trying to register were not for luxury goods, and the people that would buy those products would not go to the same store that the people looking for the fancy products would go to. So we argued to the government that there were different channels that the goods were being sold, and therefore there wouldn't be a likelihood of confusion. To give you an example, the people buying this good, they were going to, I don't know, Neiman Marcus or really high-end stores, and the people buying goods that we were trying to sell were going to Walmart, and we were not marketing to this really fancy store. So we made that argument. They also look at the sophistication of the purchasers, impulse buying versus careful, sophisticated purchasing, the fame of the senior mark, the number or nature of similar marks used in similar goods, the nature and extent of any actual confusion, the length of time which there has been concurrent use without evidence of actual confusion, the variety of goods the mark is used, the market interface between the junior and senior users, to the extent to which the applicant has the right to exclude others from use of the marks, the extent of potential confusion, any other established fact probative to the effect of use. So in other words, whenever registering a trademark, if we get something called a notice of action from the United States Patent and Trademark Office telling us we do not want to register your trademark because it creates a likelihood of confusion, we will then analyze all of those DuPont factors, really get into the nitty-gritty of who our client customers are, and see how we can differentiate the mark so that we can still go ahead and register. Okay, there's something called trademark searches. I don't perform them myself because it would cost a client a lot of money to hire me to check every single state trademark, every single federal trademark. And even if I did all that, I still couldn't give you a legal opinion that says, yes, you're going to register. So there are companies that specialize in this trademark search. We can connect you with those companies. We will work with you and hire them so they can do the search, and we will provide to you what they come back with. And it's actually a good thing to do because then it gives you an idea whether or not your mark will be protected. We do that, and then after that, we will file the trademark for you. Or we will do our own little search that won't have an extra fee, just the United States Patent and Trademark Office, to see if there is an exact name that you want to register that has already been registered for that class. And if there is, of course, we'll let you know. If there isn't, we can proceed to registration and then see what the United States Patent and Trademark Office comes back with. Either or, you can do it. It's just a little extra fee if you want to research it before. So assuming the mark is you're able to register, then we have to show that it's used in commerce. Now I was saying you can do intent to use and you can start protecting it, but they will not give you registration until you're actually using it, okay? And what is intent to use, or I'm sorry, what is used in commerce? It means that I, for example, developed a cover for this phone and I sold it to somebody in New York and I shipped it to them. That means it's in commerce. That's all it means. That is, I did a product or a service, or if it's a service that I used already the name on for that service. I have a website that shows it. I have something to show the United States Patent and Trademark Office that I'm already using either that product or that service in commerce. And we can work together to see how that would play out for your particular industry. Once you try to register, there's two registrations. There is the principal register where everybody wants to be, and then there's also the supplemental register. You go into the principal registry if you have a really fanciful mark, if you have a mark that is distinctive. You go into the supplemental registry sometimes if you have a mark that it's not, generic. So it's not apple for apple, but it's something similar. Okay, so it's something that when you hear it, you kind of already know what it is. It doesn't require a lot of imagination. So the United States Patent and Trademark Office will say, we won't put you in the principal registry, we'll put you in the supplemental registry. And then after a certain period of time, 5 years, you can actually argue that you have obtained distinctiveness and then move into the principal registry, or you can just stay in the supplemental registry. You still get a trademark. Actually, I have clients that have been in the supplemental register and other people have found out about their trademarks and they went and offered them money to buy their trademarks off of them, even though it wasn't so distinctive, but because they wanted to do business under that trademark. So it still affords you a certain level of protection. Of course, we try to be in the principal registry, but if you're not, it's not the end all be all. You can still, obtain some level of protection. Let me see. Hold on one second. I'm just trying to see if there's any questions. I can start answering them if you guys have any questions. All right. The two main paths of registration are we do the application. Basically, we say we're already using the mark in commerce and then we file it. Or like I told you, we do the intent to use. We say that we are going to be using the mark in commerce and then we file it. The United States Patent and Trademark Office has 3 to 4 months after the time we file the trademark to basically examine it. What do? They check the registry, they check state registries, they check all over the place to see if there's any conflicting marks. After those 3 to 4 months, they may issue something called an office action, which basically tells me, the attorney, hey, you need to look at this, argue this, let me know what's going on. You know, we think there is an issue with this. Whatever it is, we will find a way to answer the United States Patent and Trademark Office unless there is a big issue. We usually get 6 months to answer. Now, the client is eager usually to get the trademark right away, so we will not take 6 months. As soon as I get it, I will let you know. We'll work together on the answer. We can probably file it that same week. After we file the answer, they will, review it, and then they will tell us what they think. If there is no problem and they're like, okay, we accept your arguments, then it's going to proceed to publication. There is this federal newspaper. It's called the Official Gazette of Trademarks. Okay, it's this newspaper, and the mark, it's going to be published in that newspaper along with a description of what is being protected, what service or product. It goes to the public technically, and then people have 30 days to file an opposition. So what does that mean? They have to find out about it, file an opposition, and say, hey, that's actually a trademark that I'm using, even though I haven't registered it, don't register. This is why I think I have the right to register instead of you. Whatever it is. In all my years of practice, I've never had an opposition filed. Thank God, I don't want to. But if it did, then we'll deal with it at that moment. Let's say nobody files an opposition. Then it goes, once the 30-day period is up, now they can, the United States Patent and Trademark Office can issue you a certificate. You will get a certificate that says, here's your trademark for this particular class or products. Yay, it's good for 5 years. Now it's your job to protect your trademark. What do I mean? If you see somebody using that trademark that you've used, right, that you've obtained, then you need to tell me so I can send them a cease and desist letter. The government is not going to prosecute it for you. They're not going to go around and say, oh, I saw them using it. No, they're not going to do that. You need to do that for yourself. You need to let me know. We have some type of service that we provide to, continue checking, but it's your job to let me know, Romy, look, they're using my trademark or they're using a similar trademark. Let's send them a cease and desist letter. We send them that. If that doesn't work, then we can proceed to a lawsuit. Okay, I have a question here. How many years of non-use does it take when a trademark is considered abandoned and available for others to register? So if your trademark expires, right, so you never renewed it, then we would have to look to see that particular trademark. Maybe it could be 2 years, maybe it could be a year. It just depends to see why did it expire. Or sometimes people received a notice of action and they never filed an answer. So we want to see what was the notice of action. Why didn't they proceed to file an answer? Because maybe it's something that's not registrable. I don't know. So it's definitely something that we want to look at on a case-by-case basis. I don't want to give you a blank answer, say after a certain amount of years you can use it, because it might not always be the case. So let's send me the trademark. Let's take a look at it, and let's look at your potential liability and see what we can do. Absolutely. Any other questions? You can put them in the chat. I don't see, no, in the chat, in the Q&A. Because I don't see the chat. But let me see. Maybe I do. No, I don't see the chat. I'll see it in a minute. Okay. So what are the requirements for registration? Oh, the renewal application. I'm so sorry. The renewal application is $400 filing fee per class. And the specimens, and you're going to hear this language, specimen. What is a specimen in the trademark world? It's basically how I can show the USPTO that you're using this mark in commerce. It can be a website. It can be a tag. It can be a picture of the product with your logo in it. It can be wrapping paper. It can be anything that you tell me, Romy, this will show that I'm using the brand in commerce, and I will look at it and tell you, okay, this is good or this is not good. The trademark, we have our own fees, right, our trademark fees, but so that you know, the United States Patent and Trademark Office fee is $275 per class to file and register a trademark. A class is a grouping of products or services. So what we do is you come to us and you tell me, Romy, this is a product or service I want to sell, and this is what I plan to sell in the future. And then I examine that and I tell you, well, I think that you apply to this class, and to this class. And then maybe it's just one class. A lot of times when real estate agents want to protect either the name of their business or the name of their team, it's usually just one class. And that would be $275 that we pay the United States Patent and Trademark Office in order to protect it in that class. This fee that you see here, the $400 filing fee, is for the renewal. And that one, you do it every 10 years after date of registration. And like I told you, after 5 years of having a trademark, you might be able to file something so that nobody else can claim a right to it. So when we deal with trademark examiners, the good thing is that we have direct contact with them. These are attorneys that are working from their home for the United States Patent and Trademark Office, and we are able to solve a lot of issues. And it's not like, even though it's called trademark prosecution, it's not like we're fighting with them. We're actually working together to see if we can register your trademark. That's why this practice of law is very nice, very fun, because you're not really fighting people. You're trying to work together, not to infringe on other people's mark, but at the same time to obtain protection for your client's mark. And when we do those responses of actions, we try to narrow the identification of goods to distinguish the marks. Sometimes a client wants to put a bunch of goods, but sometimes the trademark examiner says, no, not so many goods. So we work with the client and see. Let me see what else. Once you obtain your trademark, this is very important, especially for those of you that are obtaining trademarks for products, okay, especially for products. You want to register it with U.S. Customs. Why? Because if you register with U.S. Customs, okay, people are not going to be able to import goods that, for example, copies or stimulates a trademark registered in the U.S., copies the name of any domestic manufacturer, foreign manufacturer, the treaty, convention, or law afforded similar privileges, or bears the name or mark calculated to induce the public or believe that the article is manufactured in the U.S. or that it's manufactured in any foreign country other than the country in which it's in fact manufactured. In other words, the U.S. Customs will help a registered trademark owner if they see goods being imported that are making the illusion of being part of that trademark or that are confusing it with that trademark. They will stop those shipments. If your trademark is not registered with U.S. Customs, that will not happen. So this is very applicable to people selling goods. If you're selling goods, you want to register with U.S. Customs. No, U.S. Customs will not access the USPTO website and check all the trademarks available to see if any conflict. That's not going to happen. You have to give them notice. Okay, so you have to register your goods with them to make sure that your goods are going to be protected from any trademark infringement. Okay, so registration with U.S. Customs, we can do it for you if you want, or you can do it in the form of a letter. Here, we'll give you the link. I'm going to send everybody the presentation after this, so you have everything. It includes all this information. There is a filing fee. So if you do that, if you register with Customs after you obtain your trademark, you have an added layer of protection, right? Because you register your goods here, you're able to sell them, but you also don't want people from other countries bringing them in, selling them as if they were yours when they're really not yours. And we do see this a lot. So you definitely want to register with U.S. Customs, high-end goods, lower-end goods, any goods that you're selling, you want to make sure that those are protected. Okay, so in practice, right, additional efforts are often required beyond simply recording the mark to encourage the customs and local authorities to search for the mark. So you want to make sure that you are also on top of it. If you see somebody, and I have clients that have emailed me, contact me, say, Romy, my mark is being used with my photo to sell this product. I don't even have any affiliation with that product. So there's something else that it's called the Digital Millennium Act. Let me go ahead and end the stop share. Okay, so it's called a DMCA notice. Okay, so this applies to you guys too for your pictures, right? So you take your pictures and you put them in your listing, and then you see somebody else using those same pictures to advertise your listing without permission. We can send them a letter. We can send a letter to them to stop using it, but also we can send a letter to Facebook, to wherever they're advertising it, to any website they're advertising it, saying that they're using copyrighted material in violation of the Digital Millennium Act. It's called a DMCA takedown notice, and then we can make them take that out. And I have done that plenty of times because I have clients that they're using their image, they're using their goods, they're using their name, they're not supposed to be. So we can do the DMCA takedown notice. So if you have an issue with that, you can let us know. All right, so now I'm going to start addressing some questions. Let's see. Good morning, good morning. Nationwide, yes, trademarks, the way that we do them, federal registration is nationwide. Even though you're only local here in Florida, your protection, it's gonna be all over the United States. And the great thing is that you can license your trademark. If you have other realtors or other people providing services or goods in other states that like your name, like your team, they want to use it, that's fine. If you want to, you can license them your trademark, and now you're getting paid royalties for the licensing of your trademark, and you can make money that way and still control the mark. A license, okay, it's something that you give and you can take out very easily as long as those terms are written in the contract. So it's something really good that you can do. Let me see. Will you receive a copy of the recording? Yes, I will do my best to send a copy of the recording as long as, you know, it all comes out fine. Okay, so just to give you an idea, okay, generally speaking for trademark. So let's say that attorneys will charge you, generally, $1,000 to file the trademark or $1,100 to file the trademark. That is the attorney's fees to register the trademark for you. And then you have the class fee, $275 per class. So for approximately $1,375, you can have a registered trademark that affords you protection and you can stop others from using your mark. That is the cheapest, best way to do it. However, if there are issues where your mark conflicts in use, where the USPTO finds, you know, things that will require additional attorney work, then most attorneys will probably charge you per hour to answer the office action, okay? But in most instances, it's just a simple notice action, office action that is very simple to answer, so there's no extra fee. So for around $1,375, you can have a registered trademark, protect your logo, protect your brand, and stop the world from using it. So it's actually a really good deal. Okay, I have not registered my trademark yet, but have for more than 3 years used it on my webpage with the same domain, name of my trade name. Do I have any protections? No, you don't. And I have seen this time and time and time and again. Yes, you were the first one to use it. But if somebody tries to register a mark, assuming you don't find out about it, so you don't contest it, they may be able to register that trademark. And then you may be out of luck. So you want to make sure if you're using a name, you're using a logo, remember this. Having a domain name with that name, it's not protection. Having the company name with that name is not protection. Even having a DBA, doing business as with that name, is not protection. The only protection is having a registered trademark. So please protect your intellectual property. It's extremely valuable. You can make more money from having it protected, so it's gonna work. Okay, so another question is, will this work for clothes design? My son had developed one for his clothesline. Yeah, I mean, whatever your clothesline is, you can come up with a name, and then we can protect that name for that clothing line. Absolutely. And the way we show that we're using it in commerce is we show a picture of the clothing line with the tag, and that's enough. And I have done trademarks for clothing line names. I have also done trademarks for collections, because you could also, you know, protect your collection. For restaurants, it's not just a restaurant name that you want to protect. You maybe want to protect the special dishes that you're coming out with. If they're really catchy, you want to protect them. You want to protect the chef's name. You want to protect the slogan. If you're using a slogan for your business, anything you can protect, okay? Okay. Romy, I heard that the U.S. Trademark Office in Alexandria now requires licensed attorneys only to file patents, copyrights, or trademark. Is that true? If so, when did that rule go into effect? I filed a brokerage firm last 5 years extension 1 year ago. Okay, so the new trademark rules is they don't want foreign attorneys filing trademarks in the U.S. They want U.S. licensed attorneys filing trademark in the U.S. That is the new rule. So no more foreign, because before, foreign attorneys were filing trademarks left and right. They don't want that. They want a U.S. licensed attorney to file those trademarks. Okay, let's see. I have a trademark that someone currently reached out to me to use. Also would like to file for incontestability as well. What is the price? Reach out to me. Let me put my contact information again so that we can discuss your particular situation, and then I can give you prices and we can work together and see how we can make it all work. Okay. And here's my website too. Let me put it there. All right. Can you trademark, for example, whatever name Realtor? Okay. So Realtor is a licensed trademark by the Realtor people. So you cannot trademark anything with the word Realtor unless they give you the right to use it for real estate related services. And it's actually something that I've done before, not for the specific world Realtor, but for another usage. I had a client that wanted to register a name that within that name contained another person's registered trademark. So we reached out to that trademark owner and we said, listen, we're planning to sell this type of food. You sell this other type of food, same class, same restaurant class. Can we have an agreement so that we're able to register a trademark with the USPTO? And then we were able to develop an agreement, a coexistence agreement. It's basically what it's called. And we submitted that agreement to the United States Patent and Trademark Office so that they saw that us with the registered trademark owner of the smaller name of our name were okay in filing it, and it was granted. Okay, that's what it's called, coexistence. So if you want to trademark a name that contains another registered trademark, I'm not saying you cannot do it. I'm saying we need to reach out to the trademark owner to see if we need a coexistence agreement. We found this out after we filed for the trademark, because sometimes the USPTO will see it and maybe they won't say anything. This time they saw it and they said something to us, and that is why we reached out to the trademark owner and obtained a coexistence agreement, and we were still able to register a trademark. How long does it take to register and get the official name? If not a lot of craziness, 8 months. So from the moment that you file to the moment that you obtain, it's usually 8 months. The protection will start from the moment that you filed. So technically your protection is the moment that you file it. It's just that you will not obtain your certificate until, maybe 8 months down the road. Okay, let's see other question. How do I know if some trademark or slogan? Okay, so we can search the USPTO website for you, and I can do that free of charge. But if you want an actual full-on search, there are companies that will do it. The fee ranges around $500, and they'll search, and we can connect you and see if it is or it isn't. So we can help you with that. This is a whole different topic. Are you a probate attorney? Are you looking to team? Oh, okay. So we practice probate law in our firm. And yes, my partner, I think she's going to be giving a probate class. I'm not sure for the Miami Realtors, but we do practice that. I myself don't do it, but my partner does. All right, so I think that's all for now. You guys have my contact information. I will send everybody an email with the presentation and additional information. I want you to see me as a resource in whatever I can help you with, even though today's class was about trademark and intellectual property. As I mentioned to you all, I practice business law, I do business immigration. In my firm, we do real estate, we do probate, we do litigation, and what else do we do? That's pretty much what we do, and we're here to help. So if you have any questions, we're bilingual, Spanish, English, whatever you need. Thank you so much for attending, for taking your time. I really value you. I wish you all the best. And I guess see you soon. Bye-bye.